And juror number 15, did you have your hand up, ma'am? Yes, ma'am.
I'm retired, but I go up to Centennial on Sunday nights usually. And I take care of two of my grandchildren until, I take care of them Monday and Tuesday, and then I come back on Wednesdays. And that would really be hard. My daughter, there's no openings for those 2 days at her pre-K. So that would be a hardship. And then they have a work trip. I think it was April 27th for 4 days down in Santa Fe, where I would be watching them.
Say that again.
They're going on a work trip for work.
The parents are.
Yes.
Oh, I got it. Okay.
7
I got it.
4 days.
Okay. So the parents are leaving and you would be staying with the children. I got it. Okay. All right. All right. Anyone else in the, juror number 16? Okay. Right. No, I understand it. I'm sorry for your loss. I'm also the presiding judge for probate court, so I understand what it is that you're going through and those sorts of things. Have you filed a probate action yet? Okay. Okay, I understand what it is that you need to get done there. Anyone else in this front row? Mr. Juror 18? Yes, sir.
Yes, I have actually living in 2 locations, one here and one up in upstate New York. And I have to be back there by May 1st, and we drive. And I got 2 graduations to go to. And even though I'm retired, my wife and I are both like part-time and different things.
All right. Anyone else? Juror 19?
Two jobs full time, and I'm also a full time student in college. First week of next month, I will be going up to Nebraska because my brother's wedding. And I'm so close as best man.
So when you say the first week of next, you mean April, right? Okay. And juror number 20, did you have anything? No, sir. All right. All right. Let me ask the people in this section over here. Please raise your hand if this length of trial would cause a hardship or significant hardship for you. All right. I'm going to start over here. And you would be juror number 22. Yes, ma'am.
Also a full-time student, and I'm also doing a summer semester, so I have a similar schedule to theirs, but I'm also going to start school.
Let me make sure I understand that right. Are you now a full-time student? Okay. And you're going to start your summer semester May 14th. Got it. Okay. I was a little confused about that. Okay. And where do you go to school?
University.
Okay. Thank you, ma'am. All right. And juror number 23. Yes, ma'am.
And it's hard for me to get around, and it's not controlled.
Okay. We can I've accommodated I can accommodate a lot of different kind of health issues. We have people who are or I've had jurors that were diabetic before. You can take snacks into the jury box, anything like that. Would that help? Okay. All right. And juror number 24, did you have your hand up? No? Juror number 25. Yes, sir.
On May 4th to May 6th, I'll be heading to Boston to move my daughter back here after her first year at college. And then June 1st to June 10th, we have a trip to Florida planned.
Okay. I don't have a calendar in front of me. Is the 24th through 26th, is that a weekend?
Is it my May time?
Yes.
Sorry, if I said May 4th to May 6th.
I'm sorry, maybe I misunderstood. Okay, May 4 to May 6.
Yes,
Oh,
so I have, I think it's a Thursday to Saturday.
okay.
Yeah.
Okay. And I assume that's just moving your daughter home after her semester at college or something like that.
That's exactly right.
All right. All right. Anyone else? Juror number 27.
I'm a radiology supervisor at UC Health, and we have a work trip planned to New Orleans, April 17th through the 20th.
How does that work?
It's Stevens Health and Years conference that they throw every year, and
Okay.
was one of the supervisors selected to go down there.
Okay. And when are the dates again?
17th through the 20th.
17. Oh, so that's a Monday. Excuse me, a Monday through a Thursday? Okay. All right, and next row back, juror 35, did you have any issues? No? Juror 36, yes, ma'am.
Writer for my elected daughter. Gonna work at night. Night.
Okay, so as I understand it, you take care of your daughter who has seizure issues? Okay, and you do that, or you work during the day, you work at night, okay. Okay. Juror 37, did you have any issues? Yes, sir.
Significance of Northeast teacher. School and
Okay. Are you doing CMAS right now?
we're getting ready for that, so that'll be the 3 weeks of May.
Okay. Excuse me. Juror 38. Yes, ma'am.
I'm a full-time nursing student at Leticia, and I'm also moving out of the country at first. Exactly which date.
When does your semester end?
It's like mid-May-ish.
Okay. Juror 39. Yes, sir.
Role as a financial advisor is on still.
Juror 40. Did you have any issues? No, you should be 40. 41 should be right next to you. 31. No, 31 it should be over here. What? Yeah, that your juror number this morning may have been 31, but right now you're juror 40. Or you're in seat 40. So we're referring to you by the seat number that you're in. Does that? Oh, we are. Oh, I see what you're saying. No, the juror numbers that you got when you first came in to the jury assembly room are different than the numbers I'm referring to you now. Does that help clarify what we're doing? Okay, good. Okay, so juror number 40, and the reason why we're doing that is because we have a different seating chart in here. So juror number 40, did you have any issues?
I do. I am out of town April 26th to May 2nd. Wedding.
Okay. Juror number 41, yes, sir?
I'm also a full-time student. I go to college in Denver. Most of my classes are in person and
When you say having, are you living in Denver? Okay, but you are a resident of El Paso County. You're just up there for school, living up there for school for right. Okay, I got it. I just wanted to make sure about that because that's something I'll get to later. Okay, in the back, last row there, we have, that would be juror number 49. Did you have an issue? No, you're 50. Hold on.
No, sir.
Okay, juror 50, yes, sir.
I'm just finishing a dissertation. I'm like a double-time student. I work full-time and I don't know if it matters, but I have a reliable transportation back home.
Okay. Right. Juror 51, yes, ma'am. Through when? Yes. Juror 52,
I have some guests.
like the week of April 20. I'm sorry? So it'd be like April 24. And juror 53, yes, sir.
Yes, sir. I have a major customer meeting coming up 30th. I'm doing a meeting for that first. Off the top of my head, but it is on.
Okay. When you say on the 30th, do you mean this month or next month? Of March, okay. That would be a Thursday. You'd still be able to do that.
Yes, sir.
Okay. And what was it was in preparation for,
So that the meeting tomorrow is in preparation for the 30th meeting.
okay.
We do an action level meeting prior to that so that the chairs are prepared a week out.
And you would still be able to do that because I think that we're not going to start evidence at the earliest until April 3. So you would be able to do the meeting tomorrow as well as the meeting on the 30th. Would that help?
That would help, but I also have a training that is happening. I think it's the last week in April that I would be Friday, that Friday.
Okay.
There may have been another date, but I can't think of that right.
All right. Juror 54, did you have any issues? No. All right. Juror 55. Good morning, sir.
This is one, larger landscape company here in Colorado Springs. And the other is a plant nursery with a location here in the main location, Glenwood Springs. I'm typically in Glenwood Springs, 2 days a week up there, to monitor that business also. Obviously, spring is a pretty busy time.
Right. All right. Let me start here. First row, first person would be juror 28. Did you have any issues, sir? No? All right. Juror 29.
Morning.
Good morning, sir.
It just depends on the length of the whole trial. We have a 40th anniversary trip paid for starting July 3rd through the 17th. So,
Oh, we'll be done long before then.
good, 'cause that would be relationship limiting, I think.
Ma'am? All right, juror 30?
Trips out of town, the end of March, so the 1st to the 3rd April, end of April, I believe between the 7th to a 2nd or 3rd, it's a Tuesday, and then 27th through June.
Okay,
Now I'm one of two for. I think they're starting up that actually went out to bid right now, but somebody else would.
okay. Juror number 31?
I'm a full-time student at Doherty.
Of May? Juror 32, did you have any issues? Yes, sir.
Severe case of gout, and so it's very difficult for me to walk right now. I'm doing it because I haven't been able to walk for almost 6 months. Do what I'm gonna do, but difficult for me to sit for a very long period of time. I own my own business, but I have to most of the time be around it. Exercise a little bit. It's taking me a long time to get over this.
Okay. Juror 33, did you have any issues? Yes, sir.
An insurance sales representative. Majority of my income is commission based, so being on a jury for 6 to 8 weeks.
And juror 34, did you? No? All right. And let's start again, going back over here to the second row on the end there, juror 42. Did you have any issues, ma'am?
Work part-time.
Well, that's going to take you a while to get down to Texas, right? Oh, okay. How often do you have to do that?
I typically do it every 3 months. We're questioning day to day.
Okay. And is she on her own or is she in assisted? Okay. And tell me a little bit about the part-time work that you do.
Work is an admin.
Okay. And juror 43, did you have any issues, ma'am?
Just one, my son graduates in yes and Friday.
I can tell you, along with Juror 29's issues about relationship issues. We are not having trial on May 12th because I have a graduation that I have to be at. You would be able to make that. So in light of that, would that help? Right. Juror 44. All right. 45. 46.
I'm actually recovering from a business that did open back in 2021. I have been unemployed for about 3 weeks. I did put an application and I did get a job that I'm supposed to start.
I had a hard time understanding.
Yeah, slow down, speak up and slow down. Let's try again.
So I am recovering from a business that I did open back in 2021. I have been unemployed for about 3 weeks. I did get a job at Amazon. I am supposed to start working on the 25th. And my main concern would be because I'm pretty much living paycheck to paycheck, how I would pay my rent and utilities.
I think we had Amazon here back in 2018. Okay, the case that I had that was 18 weeks, I truly understand. I truly understand the impact that it has. Well, one of the things that I found out was that many employers continue to pay their employees if they are on jury service, and I can get you a letter that says that you're here. So what I want you to do when we take a break at over the noon hour is contact Amazon and ask them whether or not they do that. I don't know whether they do or whether they don't. My experience in the last case that I had was that some large employers, and it surprised me what employers did it, but it was like Target, USAA, Walmart. There were a number of others that actually continued to pay their employees as long as they were on jury service. So what I want you to do over the noon hour when we take our break is contact Amazon and see if you can find out an answer to that question, okay? All right. Juror 47.
I am in the middle of divorce courts. I have a status conference upcoming Wednesday where our judge is setting the final. So that might impact this.
Okay. We might be able to help with that because we're all judicial officers. We understand what's going on. So, but I also can't promise anything. So, but I will keep that in mind. Juror 48.
Yes, sir. I'm the sole caregiver to my wife. A bed rest with a fractured back and wrist. Diagnosed with osteoporosis. Always a risk of fall if I'm not around.
All right. And is there anyone else that helps you do that? And then this is where I sort of start to lose it a little bit because I can't see quite that far back. But I believe we are in the next row back. This end, there you go. You would be juror 56. All right. In juror 57? Yes, sir.
I'm the sole administrator for a school district. As we come into April and to our compliance reporting.
And what district is that?
11, we've got about 100 teachers, middle.
Okay. Juror 58.
Got a medical issue. I've had my spine fused twice and fractured. It's just difficult to sit for a real extended period of time with regular breaks. And if I could stand without being a distraction.
I'm glad that you brought it up because I have this come up. It's not uncommon. It's not every case that I have a jury in, but it's actually pretty common. You might have noticed that the chairs and the benches that you're sitting in weren't made by Lazy Boy. If you need to stand and stretch or something like that in order to be comfortable, go ahead and do that. Okay. So we will be taking regular breaks. In case you're wondering, we generally take one for about 15 minutes or so, somewhere between 10:15, 10:30. And then we will take a lunch break about noonish, something like that. If you are a juror and you're sitting, if you are selected to serve as a juror, you end up in an upgraded seat from where you are sitting now. And it's a little bit more comfortable. You would still be able to stand, stretch, do any of those kinds of things. Would that help? Okay. Juror 59.
I'm usually in the 1 to 2 next time.
When does he get out of school?
It's out at 3:05.
And what happens if you're not there to pick him up?
Usually I can find somebody to pick them up.
Right, I get it. And how old is he? So, second grade, third grade, fourth grade? Okay. All right, thank you. Juror number 60.
I'm currently an attorney in private practice, I bill. So if I'm not in the office billing, then, there's no income coming in. Additionally, on April 24th, more importantly, I'm going to be working Mr. Allen as a deputy district attorney.
Oh. Mr. Allen?
Friday on Friday.
Okay, all right. I'm gonna excuse you now.
If I go back down to the
No.
jury assembly room.
Nope, you're good to go.
Thank
So we will just excuse you now. All right, juror 61 and juror 62. No issues. All right. And then next row back on this far end, juror 63. Yes, ma'am.
I am a state, the 1-year-old, and also I work from home, in between. And my one responsibility I have for my job this year is a retreat that I help.
Yeah.
What your number was that, Your Honor?
That was 63.
Thank you.
Okay, and juror 64.
Sir, I'm the only caretaker for my wife of 81 years old. Hard of hearing, severe asthmatic. She does not drive. I do all of her doctor's appointments and transportation for her needs.
Juror 65.
Possibly. I'm a stay-at-home mom too. We do have my mother-in-law and my husband when he's off work able to do it, so it would have to be some logistics.
Okay, no, I appreciate your honesty. Thank you. All right, and juror 66. Okay, juror 67. 68.
So I supplement my social security administrative. Also run an Airbnb.
Okay.
All right, yes.
Juror 69. No issues. And then going into the far back on this end, Juror number 70. No issues. Juror 71? Oh, juror 7.
I would be willing to forego. They're canceled.
Okay, all right. All right.
And if you gave me a note, I'd probably get my language.
I can, if, you know, and I can do that. For anybody who is here that is missing work or something like that, I can give you a letter that will explain that you're here and not on a beach in Cabo or something like that. So that you can have that for your employer or anything else like that. So, all right, or an airline or whatever. So, yes, thank you. Juror 71? Okay. And juror 72?
I have a trip planned, to Europe, May 24th through June 1st. Night shift at Amazon, and as of this moment, I've been up 20 hours, so. Not just.
Well, I appreciate that, but if you are selected, you're not going to be able to work. Okay, all right. Juror 73?
I have 2 scheduled travel events.
Okay. Juror 74? No issues. Juror 75? The wedding is April 29? Okay. Can you,
My wife's
okay, all right. All right. At this point in time, I'm going to ask the jurors to look around the courtroom. And the question that I have is, do any of the potential jurors know each other? All right, that's good. I've got 2 hands. Sometimes I'll get 1, and that's always interesting. Okay, so juror number 75 far back in this corner, who do you know?
grand's right there. It's gonna be Brian at my wedding.
Okay,
Wedding in Charlotte.
okay. Well, how come he's going and you're not?
I am.
Oh, you are. You're going to, okay, all right, same wedding, okay. All right, and then I thought I saw 2 other hands. Let's see, juror number 55, who do you know?
Me?
On the end, yes, sir.
Financial advisor.
Okay, and that would be, that would be juror number 39, okay. All right, anyone else? And let's see, in the back here, juror number 50. Oh, over. Back, oh, wait. Here, okay, all right. I had another hand back here. Okay, okay, all right. For those jurors who know each other, is there anything about that if you were selected to serve as jurors in this? Is there anything, if you were selected to serve as jurors in this case, is there anything that would prevent you or cause you any difficulty in serving with the juror that you know? If so, please raise your hand. All right, no response. Let's see. I'm going to go through a list of reasons that may disqualify you. one of the reasons was already given by juror number 60 if you're working for the DA's office or will be working for the DA's office. But I need to go through some of those other reasons as well. Please raise your hand if any of you are related to the defendant or any of the attorneys. No response. Please raise your hand if you have a relationship of guardian and ward, employer and employee, landlord and tenant, debtor or creditor, or principal and agent to, or are you a member of the household of or partner in business with or surety on bond or obligation for the defendant? That is a really long lawyer question asking for certain legal relationships that you may have with the defendant. Does anybody think they fit in that category? Please raise your hand. No response. Are you now or have you ever been a party in a civil lawsuit involving the defendant or have complained against or been accused by her in a criminal prosecution? Anyone think they're in that category? No response. Please raise your hand if you are a witness to any matter related to the crime or its prosecution. Anyone think they're a witness to this case? Response. Please raise your hand if you have a personal or financial interest in the outcome of this case. Anyone think they fit in that category? Yeah, no response. Do any of you have any feelings or a bias for or against the defendant or the prosecution? Please raise your hand. All right, looks like we have a couple. I'm going to go through it the same process that I did before. We had juror number 1. You raised your hand. Yes, sir.
As far as, you're asking if I have any preconceived notions of the case?
It is, do you have the question was, do you have any feelings or a bias for or against the defendant or the prosecution?
Well, just everything that I've seen, news media coverage, everything like that.
Okay.
Yeah, I pretty much have a good
Okay.
opinion.
And we'll get to that. That'll be a little bit of a separate kind of question, and we'll get to that in just a moment. But would you be able to set that bias aside and decide this case based only on the evidence that you're going to hear in this courtroom?
I can try.
Okay. And I understand that that's a tough question and it's a tough issue. And all I'm asking for is your best and most honest answer, because one of the things that is true in every case is that nothing that the attorneys say at any point in time is evidence. Nothing that the media says is evidence. The only evidence comes from this witness stand, or it's an exhibit or something like that. So you'll see somebody come in, you'll see them raise their hand, they swear to tell the truth, the whole truth, and nothing but the truth. They sit down, they are questioned by one side, they're cross-examined by the other side. And then if you're selected as a juror, the jurors actually in the state of Colorado have an opportunity to submit questions as well. Whether or not there's a process for that, and if you're selected as a juror, I'll explain what that is. But there's a process to submit questions. Now, none of that happens with the lawyers. The lawyers never get up and take an oath to tell the truth. They never sit in that witness stand and tell you anything. They are here as paid advocates. They're here to try and persuade you to a particular position in the case. The media is not a witness either. They don't come in. They're just reporting back. They may report parts of it. They may report not report parts of it. So the question is, and it may be that people have read things about this, heard things, seen things about this case, but the question is going to be ultimately, can you decide the case on the facts and the instructions that I give you? You can try. Okay. Anyone else in here? Juror 17?
Yes, sir.
Yes, ma'am.
As this morning, as I stated on the juror form, I would have trouble child abuse or very specifically.
Okay. Can you find me her juror 17? Can you give me her questionnaire? Anyone else in this group? Right, in the back, on this side. And we'll start in the front, juror 27 on the end here.
Raise my hand, but I would be willing to set outside my.
Okay. Okay. And it sounds like you had some issues, you saw some things, may have formed some opinions. Nothing wrong with that. The question is always whether or not, because it may be that you have read something and then you hear the evidence and you go, well, that's not what was reported. Or you say, well, I don't see it quite that way. So the question always is not whether or not you've read something or seen something, but whether or not you can put that aside and decide the case based on the evidence in this courtroom. And it sounds like the answer is you think you can. Okay. Then we're going to go to juror 23. Yes, ma'am.
I've gone through a similar situation. I have a granddaughter that's in prison for what she did. And it was child abuse and death, resulting in death. So I'm not sure if
Okay. And then on the end, juror 21. Yes, ma'am.
opinions is being. And I'm not sure that I can hold this at this time.
Okay. And let me tell you, we do a lot of different kinds of trials in the building. And the issue is not, I don't think there's anybody that has ever taken a position in any trial that what happened to a child was a good thing or that it should happen or something like that. The question is whether or not the prosecution has proven beyond a reasonable doubt what it's required to prove. And can you decide the case based on that evidence? Do you think that you can do that? In the next row, let's see, juror 38. Yes, ma'am.
I've seen lots of news media coverage of this. I guess I already have a preconception.
Anyone else in this group over here? Juror, I think 40. Yes, ma'am.
I followed this case.
Okay. And anyone else in that second row? Last row? Anyone in the last row? No? Right, over here. Hands. I have a couple here and there. Juror 30. Yes, ma'am.
I also have.
Okay. And that's a separate issue too. We'll talk about that a little bit differently. So when I get to that, remember to raise your hand, okay? Okay. Anyone? And juror 42? Yes, ma'am. And also in the second row, let's see, Mr. I will get there. Juror 46. Yes, sir. That's you. That is you. Yes, sir.
I went through a similar I lost a family member due and I do not have any that type of stuff anymore. That person. And recently
All right. Next row back. One in the next row back. And the next row behind that, juror 63. Yes, ma'am.
So I would have a bit of a time to decide, just that child abuse in this case. So studied. And so
A what therapist? A play therapist, okay.
kids, and so I'm always an advocate for kids while knowing the mental evidence-based background that I'm learning.
Okay. One else in that row? Uh-oh. Sorry, I must have missed you. Juror number 20, I'm sorry, 33? Yes, sir.
Yeah, I've seen a lot of stuff on like. Probably would be a little.
Okay. And again, the issue is, not even gonna go into the accuracy of social media. But even with respect to media itself, they can only report what they've heard. And I can tell you that this case has never been tried before. There are people that have never testified before. There are statements that have never been released before. So the issue is, can you set aside what you've seen and heard and decide the case based on the evidence that you hear in the courtroom? Okay. All right, and let me get back to last row again. Okay, hand over there. That would be juror 68. Yes, ma'am. That's you with the hand. Yes.
I was.
Okay. No, that's, no, I appreciate you sharing that. And last row, jurors 71. Yes, sir. Okay. Anyone else in the back row? Looks like we have a hand here. Juror 48. Yes, sir.
Was that?
Military court martial. Dealt with see rape, fiction, and service. To that point, I really didn't have any thoughts on child abuse. Pardon my heart. Crimes like that.
Okay. So I think what we're going to do right now is we're going to take a break. A couple of things. The restrooms are down the hallway. I know that there's a lot of you. And there's only one restroom on this floor. Well, one on each side. Just as you go past the glass doors and then just before you get to the glass doors on the other side. A couple of things before you go. We need to have you back in your seats. We honor the third grade seating chart here. So remember where you are, because when you come back, you have to be in the same place. If you switch places, it causes all kinds of consternation for us. So remember the third grade seating chart. Again, don't discuss this case among yourselves. Excuse me, don't discuss this case among yourselves. Don't discuss it with anyone else. And if I can have all of you leave the courtroom now and be back at 10:35. And remember where your seats are, and we'll see you then. All rise for the jury, please. Your Honor.
My coats.
Yes, yeah, you can leave anything that you want to leave here in the courtroom, you can leave here in the courtroom. So if you want to leave your coats, backpacks, whatever, you can leave it here.
Thank you.
Thank you for asking.
Okay.
who vanished 7 days ago from Colorado Springs.
I'm pleading, if anybody has any type of lead, put yourself in my situation.
I would never, ever hurt this child. And I know there's some questions out there.
Imagine how afraid Gannon is.
Hard to hear, but today we learned that Gannon was shot, stabbed, and had his skull fractured before he was found under a bridge in Florida weeks after he vanished.
Today, I got the worst news and the best news. Obviously, we know what the worst news is, but the best news is that justice will be served. And I'll make sure that justice is served because my boy did not deserve any of this that has happened to him.
On January 27, 2020, 11-year-old Gannon Stauch disappeared from his home in Colorado Springs, Colorado. What followed was a massive search effort involving thousands of volunteers, law enforcement agencies, and community members, all hoping for the safe return of the young boy. But as the investigation unfolded, it became clear that Gannon's disappearance was no accident. This is the story of the disappearance of Gannon Stauch and the arrest of his stepmother, Leticia Stauch, for his murder. Join us as we explore the heartbreaking details of Gannon's abuse and murder and the efforts to bring his killer to justice. Gannon Stauch was a cheerful and outgoing 11-year-old boy who lived with his father, Al Stauch, and his stepmother, Leticia Stauch, in a suburban area of Colorado Springs, Colorado. Gannon's father, Al, is in the Colorado Army National Guard, and his mother, Landon Hyatt, lived in South Carolina. Landon and Al shared custody of Gannon. Leticia Stauch married Al in January 2015. She has a daughter, Harley, who was 17 at the time, from a previous relationship. Leticia's previous married name was Leticia Hunt, and her married name is Leticia Hardin. From January 25th, 2020 to January 28th, 2020, Gannon's father, Al, was deployed with the National Guard. On Monday, January 27, 2020, Gannon stayed home from school. According to Leticia, he'd been up most of the night before with a stomach ache. Leticia called the school and had him excused for the day. Tisha texted Al and said she was going to stay home with Gannon for the day and that she would just make up an excuse for her work. Indeed, Leticia did come up with an excuse and told her employers that her stepdad was killed after being hit by a car and she wouldn't be able to make it in. And so Leticia Stauch's pattern of lying begins. Here's what we do know about that day on January 27th, 2020. Gannon's little sister, Lana, was at school, and his stepsister, Harley, was at work. At 8:13 and 8:17 a.m., Leticia took photos of Gannon sleeping in his bed. Of importance is the Nintendo Switch that was lying next to him on the bed. To date, the Switch has never been found. We do not know why these photos were taken, but we can speculate. And these two photos would be detrimental to Leticia. At around 10:16 a.m., a neighbor's surveillance video captured what investigators believe to be Leticia and Gannon depart their residence in Al's Nissan Frontier. It's important to know that Stauch's home had an ADT security system, and there was no motion in the home from 10:12 a.m. to approximately 2:22 p.m. the same day. Additionally, Leticia left her phone at home that day. Her cell phone was locked at around 9:56 a.m., around 20 minutes before she is seen leaving the house, and not unlocked until 2:45 p.m. that same day. Leticia and Gannon drove about 30 minutes to a Petco, where Tisha is seen on surveillance camera, but Gannon is not. She checks out of the store at 11:22 a.m. From that time until 1:22 that afternoon, Leticia's whereabouts are unknown. However, she did return to the same store at 1:22 p.m. Interestingly enough, Gannon's dad, Al, texted Gannon around noon saying, "Hey, buddy," but this text went unanswered until 1:21. It's not known if it was Leticia that responded from inside the store or if it was truly Gannon that responded with, "Can I play Zelda at least?" The question has to be asked if it was Tisha responding, because the significant event occurred on Gannon's phone around 1:43 p.m., just shortly after Tisha left the Petco. An internet search on his phone for, "Can my parent find my cell phone if it's off?" It's believed that Leticia may have been possibly deliberating on how or if she would dispose of Gannon's phone after she murdered him. Gannon's phone was found at the residence, so Leticia may not have gotten rid of it for fear it might be traceable. The Nissan returned back to the Stauch's home around 2:20 in the afternoon. Leticia exited the vehicle and entered the home, but Gannon was not seen on the video. Leticia had been without her phone all day, a phone that she was typically constantly on, yet her screen wasn't unlocked for about 25 minutes after arriving back at the house. Gannon's little sister, Lana, got home from school that afternoon shortly after 3 o'clock. Lana stated that when she went inside, Leticia told her that Gannon was asleep in her bed and that she couldn't see him. She then told Lana to go outside and play. Because of this, it's believed that Gannon was likely deceased, and Tisha was cleaning up blood in the home. Around 3:55 p.m., Al sent his son another text saying, "Hey, buddy." Sadly, Gannon never got to see this text from his dad, as the message wasn't read until 6:40 p.m. Leticia's daughter, Harley, arrived home in her white Volkswagen Jetta around 4:40 p.m. after working all day and picked up Lana. About 10 minutes later, Tisha sent Harley a text asking her to pick up carpet cleaner, trash bags, and baking soda, which Harley did. These items were likely purchased to clean up the murder scene inside the home. As of the date of Leticia Stauch's arrest affidavit on February 28, 2020, a full month after Gannon's disappearance, Harley had refused to speak with investigators. At around 6:55 on the evening of January 27, 2020, Gannon Stauch was reported missing after he allegedly failed to return home from a friend's house. His stepmother, Leticia, claimed that she had last seen Gannon when he left their home to go to his friend's house. She said he left around 3:15 p.m. and was supposed to have returned home about an hour prior to her 911 call, but that she had been unable to locate him. Her story would change dramatically over the next few days. Leticia was unable to provide the actual location of the homes she went to, the names of Gannon's friends that he was supposed to be playing with, or the names of those friends' parents. What began as a missing child investigation would soon develop into one of murder. El Paso County Sheriff's Office responded to the home at 10:09 p.m. on January 27, 2020. When they arrived, Tisha's Volkswagen Tiguan was backed into the garage. Responding officers searched Gannon's bedroom and did a limited search of the residence and took a report from Leticia. A missing person investigation was initiated, and in the coming days, developed into a murder investigation. The following morning, on January 28th, Gannon's father, Al, flew home, and Leticia picked him up at the Colorado Springs airport in a rented, yes, you heard that right, Tisha rented a 2019 Kia Rio just prior to picking her husband up. Leticia and Al drove back to their residence together. So, why did Tisha feel compelled to rent a vehicle that morning? There was no evidence that the Tiguan was not mechanically functioning or any reason why it couldn't be physically driven. In fact, unbeknownst to her husband and investigators, the Tiguan remained at the airport in the short-term parking lot till around 6 p.m. that evening. When questioned by Al about why she was driving a rental car, Leticia allegedly responded that she was concerned about putting miles on her Tiguan. During the time period that Leticia had the Kia, she would not provide its location, and Mr. Stauch never saw the car. Tisha had also told Al another story, that her Tiguan was near the French elementary school. Around 7 p.m. on the 28th, Leticia returned the rental car and got into her Tiguan, heading to Falcon. During this time, she was sending messages to her daughter and to Al, along with searching the web. Leticia also took numerous routes that would relate to the search efforts. Around 10:15 p.m., Stauch stopped near the shops at Briargate Starbucks for about 55 minutes and connected to a Wi-Fi network. At about 10:50 p.m., the Tiguan and Leticia got back on I-25 and went to a Massage Envy location near Powers Boulevard. This is where Harley worked at the time. During this time, Leticia was searching the internet for Amber Alerts and checking the Ring doorbell camera video while connected to the Wi-Fi at the massage parlor parking lot. Harley, however, was not at work at the time and later picked up Leticia in her own car at the parking lot. The Tiguan stayed in the parking lot overnight, and the Jetta got back to the Stauch home around 1:23 a.m. Leticia's phone wasn't taken off airplane mode until January 29th. That same day, January 29th, and 2 days after Gannon went missing, Leticia was supposed to meet with investigators at 10 a.m. in Colorado Springs. When she arrived, 2 hours late, around noon, she was driving the Volkswagen Tiguan. Investigators noted that the car appeared to be wet and recently cleaned. Sure enough, they later discovered video from a car wash nearby, showing what appeared to be a car consistent with Tisha's just about 30 minutes prior to her showing up for the interview. Up until this point, Leticia had spoke with investigators over the phone, but avoided any one-on-ones with them, did not want them going to her home, and was difficult at best to track down. For the interview, Leticia brought with her several pieces of notebook paper that contained notes she had written down. During the interview, she referred to her notes and asked investigators if she could just read her notes. It was at this point that Leticia drastically departed from her initial statements to law enforcement regarding the report of Gannon's disappearance. This time, Leticia said she had been held at gunpoint by a Hispanic male she knew as Eduardo, and that after he was finished with her, he abducted Gannon. In Leticia's story, she met a man named Eduardo on January 26, 2020, the day before Gannon went missing. She described him as a Hispanic male with brown hair and brown eyes, but couldn't provide any specific identifying information. She told investigators that Gannon had knocked over a candle on Sunday, causing the carpet to burn. After that incident, she drove around the neighborhood where residential construction was taking place. She met Eduardo, who was working on a house, and asked if he would repair the carpet in her home. Eduardo agreed, and Leticia provided him the garage door code, and they agreed he would repair the carpet while she was shopping the next day. Speaking of the candle incident, Leticia video recorded what happened the night before, when she alleges Gannon knocked over the candle. The audio is quite disturbing. Let's listen.
I'm just freaked out, okay? Are you sure you didn't do it on purpose? He did it. Okay, you promise. You promise. On purpose. Pinky promise. Pinky. Okay, all right. So listen. We're all right. We're gonna have to sell stuff to fix it. Okay. So we figure out what we gotta sell. We can sell the sofa. We can sell whatever, because we gotta get it fixed. So, lady, don't be mad at us and kick us out of the house. Okay. You got it?
Leticia said she arrived home around 2:30 on the afternoon of January 27th. She immediately disarmed her security system and went to the basement. She said that Eduardo was waiting in the basement, attacked her, and pointed a gun at her. Leticia then claimed that after Eduardo held her at gunpoint, he allowed her to go upstairs to greet her stepdaughter, Lana, who had just arrived home from school. Leticia said he sent Lana outside to ride her bike, then returned to the basement where Eduardo penetrated her against her will between 3:30 and 4:30 p.m. During this period, she believed she had hit her head and may have blacked out. Investigators noted that there were no injuries on Leticia's head during their interview with her. Making her story even more ludicrous, Leticia told investigators that during the attack, Gannon jumped on Eduardo's back and Eduardo was able to throw Gannon off his back and across the room. After Eduardo had finished, he had the gun held to Gannon and demanded a suitcase. Leticia provided him with a brown suitcase and a cardboard box. Eduardo then attempted to sexually assault her again, but she hit her head and once again blacked out. Leticia stated that she tried to fight off his attacks, but was unsuccessful. Leticia said that she then cleaned up the area where the alleged attack happened. She straightened up signs of disturbances in Gannon's room and cleaned up the utility room. Leticia didn't call 911 about the home invasion, rape, and kidnapping of their child. In fact, she didn't mention any of this for 2 days after Gannon had been missing. Investigators offered Leticia the opportunity to have a sexual assault nurse examiner conduct a forensics examination at a local hospital. Ultimately, Leticia did not want to have the exam completed. When given the opportunity to provide investigators with evidence that would possibly identify Eduardo, Leticia refused to cooperate. Towards the end of the interview, Leticia said she wanted to leave. Investigators seized her telephone and detained her while they obtained a search warrant to obtain DNA collection. Leticia began stuffing tissues in her pants and said she was having chest pains and shortness of breath. Investigators immediately requested medical assistance and paramedics arrived. Accompanied by detectives, Leticia was taken to the hospital via ambulance. During the ambulance ride, Leticia was unresponsive to questions by medical personnel and seemed to have a miraculous recovery when they arrived at the hospital. Leticia continued evasive behavior at the hospital, but particularly after investigators told her that they were going to issue a search warrant to collect her DNA. Additionally, they confiscated her car and towed it to their evidence facility. Leticia never did consent to a sane exam. Leticia was not in custody after the warrant was executed at the hospital and left the hospital without telling investigators. She also made a phone call from the hospital waiting room. Physical surveillance of the area showed an unknown person picking her up, and then she was reignited with her daughter several miles from the hospital. Investigators believed at this point that as pressure was increased on her, Leticia became more and more desperate to leave the hospital for fear of being caught in her own lies. Over the next few weeks, investigators searched the Stauch residence for biological evidence, amongst other. Gannon's remaining family members were still living in the residence at the time of the searches, and investigators didn't initially seal the residence off. Crime scene analysis from the Colorado Springs Metro Crime Lab responded to the residence and found traces of blood throughout the residence based on latent blood stain reagents tests. There was also visible blood in Gannon's bedroom, the garage, and other portions of the home. Specifically, on January 28th, a search was authorized by Al Stauch without the need for a search warrant. There, in Gannon's bedroom, in a corner of the room, investigators located an area where suspected blood had seeped through the carpet, through the pad, and stained the concrete. Furthermore, there was also blood stain and projected blood splatter located on the walls within this area. Indeed, Over 50 droplets of suspected blood were found on the walls near Gannon's bed. Because of the way the Blue Star Regent reacted on the wall, it was suspected that someone had attempted to clean it up. Trace evidence swabs from suspected blood were obtained from the electrical socket next to Gannon's bed. These swabs revealed that the blood was indeed Gannon's blood. The electrical socket also had evidence of streak marks, which are reasonably suspected to be from Leticia's attempt at cleaning. When investigators removed the outlet cover, a visible red stain was present, outlining its edges. The presence of that stain indicated that there was enough blood around the outlet cover to seep around its edges, leaving a visible outline. Gannon's mattress was also seized and contained a red stain consistent with blood in the same area as the stain on the carpet and the blood cast off on the walls. The stain on the mattress was swabbed, but were not tested with Blue Star Regent. It's important to note that when officers first responded to the 911 call on January
Okay. And then, juror 22, first row. Yep, that was your hand. You're right. 22, 23, 25, and 27. 37 be in the, sort of teal t-shirt with the glasses. Gentlemen, yes, that you'd be 37, 38, 40, and 41. Juror 50 with the mask on in the back. Juror 51 sitting next to him, and juror 55 on the end. You all can leave as well. Now, while you have to stay in your same seat, you can spread out a little bit more if you would like to. You get a little bit more room. Okay, and then, because this group is bigger, I'm going to excuse from the back first. So it would be juror 71, the gentleman there. Yep, you're 71, 72, 73, and 75. You can go ahead and leave. Then next row up on the end, juror 63, juror 64, and juror 68. You can leave now. 68, that's you. Yep, in the glasses. And 63 and 64, you can go ahead and leave too. You're 63 on the end. You're 60, that's all right. You're 63 and you're 64. There you go. And then next row this way, juror 60, who is the woman in the glasses.
60 was the DA that I hired.
Oh, I'm sorry. That's what threw me off. See, you guys did great. You did great. You came back, remembered your seats, but it's different because there's one guy's missing. That's right. Okay. Row next from that, forward from that, juror 48 on the end over here. Juror 46, gentleman in the black coat. And juror 42 on the end. You guys can go ahead and leave now. And then in this front row, 3. 48, 46, and 42. Yeah. Oh. In the meantime, in the front row, juror 30. Next to her, juror 31. And juror 33. Oh, aye, that's okay. Be more specific next time. It's all good. All right. Okay, the next question that I have for all of you is, are any of you an employee of any public law enforcement agency or the public defender's office? If so, please raise your hand. No response. Please raise your hand if you are not a citizen of the United States, are not at least 18 years old, nor a resident of this county. Anyone think they're in that category? Juror number 8, or yes, 8. Okay, and let me clarify for just a moment. It's actually juror number 7. I'm thrown off by the people being missing too. So juror number 7, let me make sure I understand this right. You are a citizen of West Virginia? You are a Virginia resident. Where's your driver's license? No. Where was your driver's license issued? Okay, all right. So you have a Colorado driver's license and you're living here in Colorado. Okay, all right. That counts. So you'd be okay. But thanks for raising the issue. Appreciate it. Anyone else think they're in any of those categories? And one of the reasons why we ask this question is because sometimes if you note the last part of it was, are you a resident of this county? We ask that question because we send out juror summonses about between 4 and 6 weeks prior to the time of a trial. And so we send them to that address, they get forwarded, somebody moves, and they're actually living somewhere else. So that's really what that is designed to address. Does anyone think they're in that category? No response. Please raise your hand if you're unable to read, speak, or understand the English language. Does anybody think they're in that category? Again, no response. Please raise your hand if you're incapable due to physical or mental limitations to render satisfactory jury service. Anyone think they're in that category? And is it the gout? Okay, and that's juror 32. Okay, I will, let me think about that some, and we'll see where we are. Whoops. Just a second. I think that I have addressed this with questions earlier, but because the dynamics are a little bit different now, let me ask it again. Please raise your hand if you have the sole responsibility for the daily care of a permanently disabled person living in your household such that your service would create a substantial risk of injury to the health of that disabled person. Anyone think they're in that category? No response. Oh, hold on. Oh, wait. Juror 36, go ahead. How old is she? And she gets off of school or out of school when? Okay. Anyone else? Let's go ahead and hand out the witness list now. What's going to happen is the staff is going to be handing you out a witness list. I'm going to give you a few minutes to go over it. It's long. The question that I'm going to have for you at the end is, do any of you know any of the potential witnesses in this case? And once you get done with that list, the attorneys may have a couple others that are not on that list, and I'll ask them if there's anybody else that they're going to add to that. But the question at the end is, do any of you know any of the potential witnesses? And if you see, let's see, I think everybody's got them now. There are notepads and a pen on the bar in front of you. If you need to write something down to check, please don't write on the list. But if you need to write something down, you can do that. So just let us know. And so that the attorneys know that it's coming, we're going to do a 2-minute mini opening statement in just a minute. While we're taking this break, did council need to see the strikes that I had? Would that help? Did you get them as I was going through them? Mr. Allen, are you guys good over here with the strikes that I went through up to speed?
Yeah, the ones that you've already announced, yeah.
Yeah, okay. I just want to make sure everybody's on the same page. looks like most everybody, does anyone need more time with the witness list? Please raise your hand. Looks like, okay, all right, that's fine. I'm not trying to hurry. I'm just trying to gauge where we are. And when you're done, just pass it to the center or pass it up to one of these, either Mr. Combs or Mr. Sproul.
It's not signed.
All right. And prosecution, are there any other witnesses which the prosecution may call that were not on that list?
Not that we're aware of at this time, Judge.
Jack, we got one more back there. And from the defense?
Possibly Dr. Rhonda Niederhauser and possibly investigator.
Okay. Does anyone think they know any of the potential witnesses in this case? If so, please raise your hand. Okay, looks like we have a few. Let me get back to my list here. Juror number 11. Yes, ma'am.
Your Honor, I know Investigator Colvin on a professional level.
Okay. And where does Investigator Colvin fit in?
She's one of our DAO investigators, Judge.
Okay. And how do you know Investigator Colvin?
Because I'm a DHS welfare fraud investigator, so I create my own fraud case and give it to her. She then verifies and gets the arrest warrants out from the DA's office on my cases.
I've done some of those. So you work with her on a daily basis?
Not daily, Your Honor, just when I have a case that breaches the statutes of felony fraud.
Okay. And well, let me ask, do you have any knowledge from your contacts with her about this case?
No, Your Honor.
So the concern is that you do know her on a professional basis, work with her regularly, those kinds of things. Do I have that right? Okay. Do you think that you would be able to set aside, well, let me ask, is she a coworker or is she a friend or both?
I would say more a coworker. I don't know on a personal level at all. I just know that she does take a lot of my cases that I give to the district attorney, verifies, looks at my stuff, figures out what statutes the charges will go under, because I don't have that option. I just say this is what they did.
Okay.
And then we discuss those, but we've never discussed anything more than professional case.
Okay. Would you be able to judge her testimony? I don't know whether she's going to testify or not. Let me tell you that.
Okay.
Oftentimes what each side puts on their witness list is somebody that they may call. That doesn't mean that they're going to call them. And it may be somebody that has some peripheral, I mean, for all I know, she may have put in some information on a computer screen one time and that's it, but they need that witness to establish some foundation. It's also possible that there was some investigation by that person. That person will be testifying about a critical piece of evidence in this case. So it could be from one extreme to the other and anywhere in between.
Mm-hmm.
The question that I have for you is, would you be able to judge the investigator's testimony just as you would judge any other testimony that was given by someone?
Absolutely.
Would you find her to be more credible just because you know her? Okay. All right. Thank you, ma'am. And juror number 7? Yes, sir. Okay. And how do you know that person? Oh, you were both in the military together? Okay. Do you know this person since they left the military? Oh, he's still in the military. Probably not the same guy, is it?
Can we get a copy of that list back so we can follow along?
Sure. I need one too.
Thank you.
And what was the name again? Ian Marks. Just, okay. And prosecution, how does Mr. Marks fit into the case?
Judge, he's more the way you described the very peripheral type witnesses. The chances that we actually call him is very, very low.
Is this person actually in the military though?
I don't know that off the top of my head. We can look into that though.
Okay. Let me ask you then, check into that while we're talking about it. Juror number 7, let me ask you, if Mr. Marks were to testify, would you be able to judge his testimony just as you would anyone else's testimony? Would you give it any greater or lesser credibility because of I'm not even exactly sure what your contact is with him. Okay. Okay. So would you be able to just judge his testimony just as you would anyone else's? Okay. Anyone else in this group? No. All right, back here, anybody know any of the witnesses? Juror 36. I didn't hear that last part all the way. She what? Okay. Okay. And how well do you know her, or do you just know her in a professional capacity, or? Okay. Oh, got it. Okay. And how long have you known her? Okay. Okay. And is she a friend, a work acquaintance, or what? Would you be able to judge her testimony just as you would anyone else's testimony? There's no right or wrong answers here. Okay. Anyone else in this group? Okay, let me go in the far back there, juror 49.
Your Honor, I did not hear the second addition from the defense. I
Sorry.
apologize.
Caitlin, correct. She's an investigator.
I'm good.
You're good. Okay. All right. And then juror 53.
I'm not sure about Greg Horsley. The name sounds familiar to me. It's not close, or it's not someone I'm close to, so I don't have a problem.
Okay.
And the other one is Doug Niederhauser. My wife has worked professional. My ex-wife has worked with her.
Okay. Anything about that you think would cause you any difficulty judging her testimony? Okay. In this group, anybody know any of the potential witnesses? And then let's see, we are juror 58. Yes, sir. So, well, let me ask, more than 3 years ago? Okay. All right. So anything about that you think would cause you any difficulty judging his testimony? All right. Thank you, sir. Anyone else over in this group? Is there anyone that I missed? And let me go to juror 39. Do you know anybody on the witness list, sir? In the blue shirt? Do you know anybody on the witness list? Okay. All right. All right. At this point in time, I'm going to give the attorneys an opportunity to provide you with sort of it's a mini opening statement. It will be, it's going to be about 2 minutes long, and it's going to be their opportunity to tell you what they think the issues in the case are. It's not necessarily what you'll find them to be if you're selected to serve as jurors. Remember that nothing that the attorneys say at any point in time is evidence. With that, prosecution.
Thank you, Judge. And is it okay if I stand sort of, I don't need to be
Yeah.
in front of the microphone?
No, you can use the well. You can wander around. That's fine. Just speak up so that they can hear you.
So the case that you're going to potentially be sitting on involves a young boy named Gannon Stauch. He was 11 years old on the weekend of January 26th, which was a Sunday. And he was left in the care of his stepmother, the defendant, at their home in the Lorson Ranch area, which is sort of southeast part of Colorado Springs, very close to the airport. Gannon's father, Al Stauch, is in the National Guard and had traveled to Oklahoma early that Sunday morning for training, leaving Gannon with the defendant. Sometime that night, Gannon suffered some burns. And then the next day, on the 27th, which was a Monday, he suffered some really horrific injuries, including multiple stab wounds, blunt force trauma to the head, and gunshot to his jaw. The person, again, that was in custody or control of Gannon was the defendant. And the evidence will show that the defendant hid some evidence up by Palmer Lake, a bloody board, and potentially some other information, and then drove Gannon's body to Florida and dumped him in a suitcase over a bridge over an estuary or a river, and then was eventually arrested in Myrtle Beach, South Carolina. You'll hear lots of testimony about forensics, including cell phone forensics, showing travel locations, evidence about crime scene processing, including blood pattern analysis. And at the end of all of this evidence, 6 weeks roughly of evidence, we will come back to you and ask you to find the defendant guilty of the crimes that the judge has already laid out. One of the big issues is that the defendant has pled not guilty by reason of insanity. So you will have to weigh out whether she's guilty or not guilty based on the charges that we'll present to you, and also weigh out whether insanity existed at the time that these offenses occurred, and whether that weighs into her inability to form the intent required to commit these offenses. Really, at the very boiled down way to look at that is, could she understand back then on January 27th, 2020, the difference between right and wrong? And we will come back to you asking you to find that she could understand the difference from right and wrong and find her guilty of the crimes that we've already laid out for you. Thank you.
All right. Thank you. Defense, Mr. Tellini.
Ladies and gentlemen, you're going to hear about 8 weeks worth of evidence. There are all kinds of people come from all over the country. You're going to hear evidence about cell phones. You're going to hear evidence about computers. You're going to hear evidence about Facebook. There are literally going to be days and days of evidence. But what you will not hear from this side of the table is any type of reasonable explanation why Leticia Stauch would have done this. We hear from friends, neighbors, teachers, other people, that all that they observed is that she was a loving stepmom. She was a loving stepmom to Gannon. You'll hear evidence from experts and other people about her unraveling mental state in the weeks leading up to this homicide. You'll hear evidence how finally in the day before this horrific event, due to numerous mental health issues that she has, she snapped and was in a psychotic state. Ladies and gentlemen, we believe it will be clear that the only explanation for this horrible act was that Ms. Stauch was insane at the time that it occurred. Thank you.
All right. In this case, you will be asked to render a decision based on the evidence presented in this courtroom and the instructions that I will give you. Even if you have heard or read something in the media, the real question is whether or not you can put that aside and decide this case based on the evidence you hear in this courtroom. Is there anyone here who thinks they cannot do that? Juror, start in the front here. Juror 17. Yes, ma'am. Tell me what the issue is.
Yes, sir. I suffered abuse at the hands of a neighbor. I do carry a lot of anger about it, and I would like to sit here and tell you that I could go through with this without bias, but I just can't tell you that for sure.
Okay, that's fair. And juror number 9, did you have your hand up? Yes, yes, ma'am. Or I'm sorry, you are 8. I'm sorry. Bring me off again. The empty seats. See, I get confused too. All right, juror number 8.
I thought I don't think I can make this be not biased on what I've heard. And
In this group? No. How about back here? Anyone back there? No. Hold on. That is juror 35. Go ahead. Okay. All right. The question is whether or not you can hold the prosecution to their burden of proof, and they have to prove everything beyond a reasonable doubt. They also have to prove that she was sane beyond a reasonable doubt. So it's their burden to prove all of that. The question is, do you think, okay. All right. Anyone else in that group? Okay. And anyone over here in the back? And this is what's going to throw me off here. I think you're juror number 67. Yes, ma'am. That's all right. It's okay. What interview are you talking about? Oh, okay. Okay. And just so that I understand exactly what it is you're talking about, she's being interviewed by a news person and she's standing with her back to the camera. Is that the one that you're talking about? Okay. Anyone else in this group? No? All right. I want to go through some instructions, and especially an instruction that you will receive later that is especially important for you to consider now. You may hear the attorney's comment on the law at various points of the case. However, you are to be guided by what I say about the law. In this case, every person charged with a crime is presumed innocent. This presumption of innocence remains with the defendant throughout the trial and should be given effect by you unless, after considering all of the evidence, you are then convinced that the defendant is guilty beyond a reasonable doubt. The burden of proof is upon the prosecution to prove to the satisfaction of the jury beyond a reasonable doubt the existence of all of the elements necessary to constitute the crime charged. Reasonable doubt means a doubt based upon reason and common sense, which arises from a fair and rational consideration of all of the evidence or lack of evidence in the case. It is a doubt which is not a vague, speculative, or imaginary doubt, but such a doubt as would cause reasonable people to hesitate to act in matters of importance to themselves. If you find from the evidence that each and every element has been proven beyond a reasonable doubt, you will find the defendant guilty. If you find from the evidence that the prosecution has failed to prove any one or more of the elements beyond a reasonable doubt, you will find the defendant not guilty. A few minutes ago, you heard me tell you that the defendant was presumed to be innocent. That means that if I were to give you a verdict form right now and ask you to fill it out, the law would require that you find the defendant not guilty. That's because you've not heard any evidence in this case, and the defendant is presumed innocent. And that doesn't change because the attorneys got up and told you what they think the evidence is going to be, because nothing that they say is evidence. In addition, someone in a few moments, the attorneys will have an opportunity to ask you some questions. But somebody else may ask you whether or not you think the defendant has done something wrong, or else you wouldn't be here. However, that is an improper question under our system of justice. We don't just randomly select people from the street to suddenly appear in a courtroom as a defendant in a case. Obviously, there is a process in place which resulted in the filing of the charges against this defendant. However, the charges against the defendant are not evidence either. The charges against the defendant are just accusations. The fact that the defendant has been accused is not evidence that the defendant committed any crime. As such, the defendant is presumed to be innocent, and until the district attorney presents sufficient evidence to overcome the presumption beyond a reasonable doubt, you must continue to presume the defendant is innocent. Stated differently, unless and until the prosecution presents sufficient evidence to overcome the presumption of innocence beyond a reasonable doubt, Ms. Stauch's guilt has not been proven. That's what the presumption of innocence means. You may also find it helpful to think of this process as sort of similar to a recipe in a cookbook. That's because the charges, once you see them, have certain things in them that the prosecution must prove beyond a reasonable doubt. Now, for instance, suppose that you wanted a Denver omelet, and you took some eggs and you scrambled them up and you added some ham and you added some mushrooms. In that case, you might have a really nice ham and Swiss omelet, but you wouldn't have a Denver omelet. If the prosecution charges the defendant with a Denver omelet, they have to prove a Denver omelet. There's no substitutions on the menu that are allowed. The prosecution has to prove beyond a reasonable doubt what it has charged and not something else. I also want to talk about the defendant's right to remain silent for a moment. Someone may ask you whether or not you would need to hear from both sides in order to be fair. Everybody wants to be fair, right? And you can only do that if you hear from both sides, right? However, that is an improper question because that's not the process that is followed in a court of law. This isn't the Jerry Springer or Maury Povich show. The government brought these charges against an individual. Because of that, the government has the burden of proving beyond a reasonable doubt every element of the charges that it brought. The defendant has no obligation to disprove the government's case. Stated differently, the defendant does not have to present any evidence or any testimony. In fact, I suspect they're not, but defense counsel could choose to take a nap at defense counsel table, and it would not change the prosecution's obligation to prove every element of the charges beyond a reasonable doubt. In addition, every defendant has a constitutional right not to testify. The decision not to testify cannot be used as an inference of guilt and cannot prejudice the defendant. That's because it is not evidence, does not prove anything, and must not be considered for any purpose. Now, sometimes you'll hear when you're talking with friends or family or acquaintances, or sometimes the attorneys will ask a question designed to elicit a response from you similar to, well, I know that if I were accused of something, I would make sure I took the stand and told my side of the story. As I indicated earlier, that's kind of a trick question because that's not the process that we follow in a court proceeding. In any event, does anybody here know statistically what the #1 psychological fear is in the population? It rates higher than a fear of death, and most people find it scarier than meeting up with a rattlesnake. Public speaking. So, of course, what we do is we bring you all down and ask you questions in front of a lot of other people asking you for responses to those questions. All of you have been subject to questioning by myself. In a few minutes, you'll be subject to questioning from the attorneys. And I want you to think on that experience for a moment. Were you nervous? If you had a choice, would you have chosen not to be questioned? And none of you were questioned in front of a jury, and none of you were either a witness or been accused of a crime in this case. The bottom line is that it is possible that the defendant won't testify. It's possible that the defendant will testify. But regardless of who testifies and who doesn't, the question is always the same. And that is, based on the evidence presented, whatever that evidence is, has the prosecution proven beyond a reasonable doubt that the defendant is guilty of the crime charged? Is there anyone who thinks that they cannot follow that process? Please raise your hand. Is there anyone who thinks that they would have to hear from the defendant before deciding the issues in this case? Please raise your hand. No response. All right, and at this point in time, I'm going to excuse Juror 17 in the front, Juror 8 in the back, and Juror 67. You're all, I'm going to excuse you at this point in time, and you can go ahead and go on about your business. All right, we've asked you all questions about the length of the trial and publicity and those sorts of things. I do want to ask some questions about the plea of not guilty by reason of insanity. Give me just a moment. Is there anyone who has, and I may have already excused this juror, is there anyone who has an issue simply with the plea of not guilty by reason of insanity? All right, and let me start back here first. Juror 52, you raised your hand. Can you tell me what that is?
I'm probably gonna be a witness in the trial. My best friend was, and her husband were both guardian son. He's really a nephew, but they had guardianship of him.
Oh, okay, all right, that made a little more sense to me. Go ahead.
And his plea is insane. So how much I hear about and he's friends with nearly
How long ago did that happen? Okay. And that case, is it here in El Paso County? All right, and has it been scheduled for trial yet?
it has off and on and has evaluated one point being other point.
It sounds as though then that case is probably being prosecuted by Mr. Allen's office. It's a criminal case. Do I have that right? Okay. Has anyone, I guess on either side, spoken with you about the process of how evaluations occur and what it means to be found insane or not insane? Okay, so you're looking at the facts as you know them to be in that case and wondering how can this possibly be? Is that, do I have it sort of right? Okay. And I suspect I've done sanity cases before, and that's actually, frankly, a fairly common issue is how did all this occur? And you would, if you are selected to serve as a juror in this case, you would receive instructions about what it is that you're supposed to look at and what the law is governing a plea of not guilty by reason of insanity. And I don't want to read them at this point in time. It's hard to put them in context until you actually have the evidence to see what they are. But the question would be whether or not you think that you would be able to decide the issues in this case and make a determination regarding whether or not the prosecution has proven beyond a reasonable doubt that the defendant was sane at the time that the offense was committed in this case. Okay, all right. And then juror number 53, you had raised your hand.
My ex-wife.
That's right. Yeah.
And I have a bias against Elmfield in general because she used her knowledge to do it.
When you say she, do you mean your ex-wife or some? Okay, go ahead.
And said that I was the problem in the marriage. There was problems in the marriage. I can take some responsibility. I just struggle with that.
Okay. And how, tell me a little bit about the kind of work that your ex-wife did. I remember that she worked in the mental health field. What was it that she did?
She deals with, she's at LPC, licensed professional counselor, and she works with trauma.
Does she work in a hospital or is it a private practice?
Just private practice now. She did work at Stauch.
How long ago was that? Okay. And when did you separate?
Separated. Last time it was August, I think. The divorce is filed.
So August of last year? Okay. And when she came home, was she telling you about, in general, the patients that she had seen, the issues that she was dealing with, those kinds of things?
General, yes.
I'm just trying to get an understanding of what knowledge you may have about sanity or not guilty by reason of insanity from your wife.
Just that based on her experience that there are broken people, and I fully agree with that, but she said that there are also people that.
Okay. All right. Did I get everybody over here? How about over here? Any hands over here? Nope. All right. All right. Council approach, please. So give me just a moment, and I think we're going to take an early lunch break. So give me just a moment. All right, at this point in time, I'm going to excuse juror 32 here in the front row. The gentleman with gout, you don't need to come back. I will also excuse juror 52 and 53 in the back. I will give them a chance to leave, and then I'll talk with you for just a little bit longer here. Okay, so what we're going to do is we're going to take our lunch break a little bit early. That'll do a couple of things. First of all, the lawyers have a lot of work to do because they're going to be looking through questionnaires. And when we come back, here's what you can expect. The attorneys will each have 45 minutes to question you regarding topics that they want to cover. And then when we come back, the prosecution will start. Prosecution has the burden of proof, so they almost always go first. And they will start asking questions of everyone. They're going to ask questions of everyone in the courtroom as opposed to just the people in the box. If you are in this room, you should anticipate that you will be on this jury in this case. It may not be today. As I said, we hope to start evidence on April 3rd, but you should anticipate that you're going to be on the jury in this case. So if there are issues that you need to raise or want to raise, you need to tell us those because I can't do anything about it after we have selected the jury. So the attorneys will start their questioning. They'll have 45 minutes per side. At the end of that questioning, what will occur is that I'll send you out in the hallway again for a break. And actually, I'll send you out in the hallway at the end of the prosecution's questioning so that you're not sitting there for an inordinately lengthy period of time. Then we'll have you come back. Defense will have an opportunity to ask you some questions. Then what will occur is the attorneys will come up here and we will have we will have some discussion about potential challenges for cause. And then I will excuse those jurors. Then we will have some jurors left. I do not anticipate that we will have all of the jurors that we need out of today. So that's why we have set aside 2 weeks to select the jury in this case. While the attorneys and I are having a conversation up here, you get to listen to, we don't play music, you get that instead. But it's wonderful white noise, so I don't know what hertz or frequency it at, but should put you at ease. So in any event, we will then have some jurors who are qualified to be on this jury. We will have those jurors come back on April 3. We'll give you a card about that. Here's what a couple of things to keep in mind. First of all, when we take our break, you're free to leave the courthouse. There is a bistro that's in the basement. I think it's open today. Yeah, okay. There's a bistro that's in the basement. Most of the eating joints are north on Tejon. A few of them are south on Tejon. But come back and be back in place at, say, 1:15. We'll open the doors at 1:15 to allow everybody back in so that we can start at that point in time. I cannot start until everybody is here. So I need everybody to be here on time, and then we will be able to go. You've heard a little bit about what this case is about. You've had a lot of questions from me. You're going to have even more from the attorneys. Do not go online or check anything about this case. Okay, don't check out the attorneys. Don't check out myself, any of the staff that are involved. don't do any investigation about any aspect of this case. Once this case is done, or once your obligation is done here and you're released, you can do all of that you want, but you cannot do it in the meantime. So if you run into a story that mentions, oh, this jury is going, just swipe right or left or whatever it is that you do, I don't know. If you are on a page and you're looking at a newspaper and you see something about it, go to the next page. I'm not saying that you can't be on the internet. I'm not saying that you can't watch TV or listen to the radio or anything like that. But if you start to hear something or see something that has to do with this case, ignore it. Change the station, move the page, do something else, flip the newspaper over, whatever it is that you need to do. So with that, if we can have everyone back at 1:15, stacked up in the hallway at 1:15. We've got lots of benches out there, and there are a lot fewer of you now than there were this morning. So there should be plenty of room out there, but be there at 1:15. Also, please, 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 while you're in the hallway, I know that it's uncomfortable, and I know that this whole process is uncomfortable. But please stay quiet out there. There's still other business that's going on in the courthouse and in this hallway. We don't want to interrupt or disrupt what's going on elsewhere. So with that, we'll see you all back at 1:15. All rise for the jury, please.